Hello, my name is Kirsty Creighton, and I am the Manager of Program Development at the Alzheimer's Society of Nova Scotia. Thank you for joining us for session 2 of this 6-part Family Caregiver Education series brought to you by the Alzheimer's Society. The content of this session could bring up questions and emotions. There will be a phone number to call for support at the end of the presentation. Next slide, please. We are gathered today on sacred land that has been the site of human activities since time immemorial. We are in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq people, and we acknowledge them as the past, present, and future caretakers of this land. Next slide, please. The objectives of this session are, as you see, to provide basic information about financial and legal issues, to understand terms and tools used for care planning and future decision-making, and to encourage informed discussion and decisions about financial, legal, and personal care planning. So for this session, I would like to welcome and introduce our guest speaker, Jessica Lyle. Jessica is a lawyer who works in Dartmouth. She has focused her practice on estate planning and probate since the new Probate Act came into force in Nova Scotia in 2001. You may have heard her on CBC's Maritime Noon. Jessica speaks regularly to groups on estate-related topics. When Jessica is not working, she's busy with her husband, children, and her dog, Banjo. So take it away, Jessica. Thank you.
Thank you very much, Kirsty. So welcome all. I normally do these presentations live, but we're kicking it up a notch and doing an on-demand program, so that's exciting too. So I invite you all to sit back and understand that we're going to be doing a very high-level discussion of why essentially planning is important. Kirsty mentioned in the prior slide about financial information. Tonight isn't so much about me giving financial information so much as it's about making sure that you're aware of what documents need to be in place if we are looking after somebody's personal care and their financial care. Primarily the focus today is, of course, while somebody's still living, but we're going to touch briefly on what's involved when at death as well, and touch on a will. In this regard, part of this series was designed to support family I can't speak English. It was designed to support family caregivers who are supporting people with dementia. And that's an incredibly important role, of course, but this presentation is designed as much, in my mind, to supporting you and making sure that you as caregivers are also aware of the documents you need in place, but also that the person with dementia is aware of the documents they need in place and whether there's still time to get those documents in order if they're not already. It's incredibly important that this planning is done at the optimal time, ideally before we lose our capacities or our abilities to understand the repercussions of what we're asking to be done have diminished. So the sooner we can get them done before we're being driven by crisis, that's better. It's better, of course, because it means that we have control over our own affairs. It's also important because it means that we've actually taken steps to get things in order ahead of time before we're in that crisis scenario. But frankly, one of the questions that comes up time and time again is, what is the cost involved? It's always going to be cheaper to get your affairs in order before there's a crisis that's driving that. If somebody's ability to comprehend the documents they're looking to have prepared and signed, if that ability to understand is in question, then the lawyer involved, for example, is going to have to meet with that individual numerous times to make sure that they are comfortable that that person understands the full impact of what they are trying to put in place. And the more times that somebody meets with a lawyer, typically it's a bit more expensive each time. And so we want to try and make sure that everything is done at a time, ideally, that people can tend to these affairs without having to have undue meetings or expend undue cost. So one of the things I always do with these presentations is start a little bit about terminology. And of course, my understanding today is that our audience is not just Nova Scotia, which of course is my primary area of practice, but also our fellow maritime provinces and Newfoundland. So we've got the 4 Atlantic provinces potentially taking advantage of this presentation. In that regard, that ties into one of the issues I want to raise, and I always raise in these presentations, which is the terminology that's used. Every province in Canada has equivalent type documents to what we're going to be talking about today. And each province in Canada, as well as other jurisdictions outside of Canada, all have different terminology for those. So when we're talking about who steps into our legal shoes, whether we're incapacitated during life or at death, the terminology may vary from province to province, but the essence is the same. So again, this slide is more with the Nova Scotia context. But for example, this pretty much applies in all three. No, that's not true. All 4 provinces to a degree. Trustees and executor. The trustee, the executor, and the personal representative all tie into our will when we are deceased. So some people hear the word trustee and they immediately think, oh, that must be for a larger estate. That's actually not correct, insofar as an executor, who is the person we name in a will, an executor is deemed to be called a trustee under the Income Tax Act, for example, and their role really is to execute or administer the estate, but they receive all of our assets in their hands as trustees. We trust them to hold on to those assets. So Kirsty, who introduced me, if I name her as my executor, my will says I leave everything to Kirsty upon trust to then administer as follows, and then she does what she needs to do based on my document. So that's why the term executor and trustee can be interchanged frequently and frequently are. Trustees can also be different. So if I have a minor child, I might say, Kirsty, I would like you to be the trustee of my estate and be my executor, but I want my sister to be the trustee for any funds I leave for my minor child. So that's part of why the term trustee gets a little confusing, because it's possible to have different trustees in one will. In Nova Scotia, our Probate Act says that whether it's an executor, or if somebody dies without a will, the person who applies to the court to look after the deceased individual's estate is called administrator. So if I have a will, it's an executor. If I don't have a will, I have an administrator. But our legislation in Nova Scotia says we're not going to keep referring to executor and administrator interchangeably throughout. Instead, at the very beginning of the legislation, they define whoever is acting to administer an estate is called a personal representative. So many other jurisdictions also have a term, personal representative. I do see frequently. Off the top of my head, I can't think of what the terms are in the other 3 Atlantic provinces, but I do believe 1 or 2 of them also use personal representative. In any event, I've started seeing some wills where that term is actually used. I appoint Kirsty as my personal representative. Again, it will work, but the term executor is the term that most people are familiar with, but it can be used interchangeably with these terms. In Nova Scotia, our personal care, anything to do with our physical body, is dealt with under our Personal Directives Act. So I'm going to come back to the legislation shortly, but the person that we name in those documents is called our delegates, or our delegate, because we can actually only name one at a time. By way of example, though, in New Brunswick, the legislation that's at play for personal care is the Power of Attorney for Personal Care Act. Or sorry, no, it's the Powers of Attorney Act, but either way, the document is called the Personal Power of Attorney for Personal Care. In Prince Edward Island, the document is called a Healthcare Directive, and in Newfoundland, it's called an Advanced Healthcare Directive. So we've already got 4 different terms used for the names of the documents in those provinces. And for example, in New Brunswick, where it's a Power of Attorney for Personal Care, it's not a delegate that's named, it's an attorney. So that can be a little bit confusing as well, but just understand sometimes you have to dig a little further if you're helping yourself on Google to figure out what documents are what. Just make sure you've got the right terminology, which brings us to the issue of attorneys. In Nova Scotia, the person who's named as an attorney is the individual named in a power of attorney, which is for our financial matters. So again, I'm going to talk about the documents shortly, but the person named the attorney is the individual who steps into my legal shoes, for example, if it's my power of attorney, and looks after my affairs. The attorney does not have to have a law degree. I tend to say that's courtesy of American TV. We tend to think attorneys immediately mean lawyers. And so I have some clients who come into me and say, oh, so you have to be the person named in my power of attorney because you're an attorney. No. In Canada, I always like to say in Canada, we are supposed to be, for the most part, lawyers. Sometimes we're called counsel, we're barristers, we're solicitors, but the term attorney as a lawyer is technically an American term. In Canada, we're not really attorneys, although you will hear it again on TV. You will hear it in some jurisdictions where they do a bit more cross-border work and they work with a few American lawyers who are attorneys. But when I hear the word attorney in Canada, my immediate thought is it's somebody named in a power of attorney document. And again, depending on the province, that may be purely a financial role. And then in other provinces, by way of example, New Brunswick, it can be, again, a power of attorney for healthcare or a power of attorney for financial matters. So in Nova Scotia, when I hear attorney, I know it's a financial matter. And if I hear delegate, I know it's a personal care matter. If somebody has lost capacity, if your loved one is in the sort of far stages of dementia or Alzheimer's, and it's clear that they can no longer make decisions about who to name as their delegate or their attorney or their executor for that matter, the reality is at that point, they are unable to put into effect those documents themselves. And so then in Nova Scotia, we have a scenario where we need to look for what's called, well, frankly, our next best option. So on the healthcare side of things, on the personal care side of things, there is a statutory decision maker set out in the document, which means if I don't have a delegate, the presumption is that it looks to family members in a certain order. I have to have had contact with them within a certain period of time. The problem is, for example, children are ranked as one. And if my children are fighting with each other, then the statutory decision maker provision isn't going to be helpful, because the legislation in Nova Scotia is very clear that only one person may be named in a particular role at any time. And if my 2 kids or my 3 kids or my 4 kids are fighting about that, then this statutory decision maker default is no good. If that's the case, then in fact, my family member or members who's determined that they want to look after me is going to have to go to court. In Nova Scotia, it's called an application under the Adult Capacity and Decision-Making Act, and they go to court to be appointed my representative. I've left the term guardian there because in other jurisdictions, that application is for it's for guardianship. That's still the language they use. In Nova Scotia, the term guardian used to apply to adults and minors. Since the very end of 2017, the term guardian applies to people under the age of 19 in Nova Scotia, so minors. And then if it's for somebody who's lost capacity, who's over the age of, or rather age 19 or over, then it is a representative who is appointed. In other jurisdictions, they're called different names, but the reality is it's a court appointed role. And if I don't have a power of attorney, my family members, if they need to be able to look after my financial affairs, there is no statutory decision maker provision in our powers of attorney legislation. New Brunswick has some very nice new legislation, and they, I think, may have, but don't quote me on that. But in Nova Scotia, if I don't have a power of attorney, then my family members have no choice but to go to court to seek representation over me to be able to look after my affairs. So one final note before we start talking about the documents. This is a little bit, the first part is a little bit of a Nova Scotia pet peeve. The second one is a bit of a legal lesson. The term next of kin is used a lot in Nova Scotia. When we go to hospital, if we go to for any sort of procedure or blood test or x-ray or what have you, when we check in at the hospital, we are typically asked who is our next of kin. And the reality is that is not a legally defined term for the purposes of what we're talking about today. What they should be saying is, do you have a delegate? But they don't. The paperwork used to say next of kin. It's a very difficult discussion sometimes to have with people because they spend all this time thinking about who to name as their delegate, and then they go to the hospital and they're asked who's their next of kin, and they give a name of somebody else who's not their delegate. And the problem is occasionally whatever they're in the hospital for means that the next of kin is called to make a decision or do something. And in fact, the person who should be called is the delegate, and when they're not the same, that's problematic. So that's my little pet peeve lesson number 1. So be sure that there's consistency between who you want to name in those documents and who you're naming when you walk into the hospital and say who's supposed to be next to be called. And then very quickly, the term capacity is the term that we use most frequently these days to do with, you know, somebody of diminished capacity, is their ability to do things, is it declining? Do they still have capacity to go talk to a lawyer, etc. Legally speaking, the terms capacity and competency actually have two different meanings. Capacity is the ability to do something at a particular time, at a particular place, the nature of the activity itself. It's fluid. I may be quite lucid and able to remember things when I'm comfortable in my home. I've had time to wake up and have my medication kick in. I haven't had to leave my house. I'm in comfy clothing, and I'm being asked to meet with somebody new. I may be a little uncomfortable, but all these other things that keep me comfortable mean that when I meet this new person, yes, I may have a few slips in my memory, but I'm still able to, in fact, function quite capably. You take that same individual at that same time of day, so maybe that's their best time of day, but you say, here, I'm putting you in the car because I'm taking you to the lawyer's office to update your documents. And all of a sudden we have potentially, the timing in my example, hopefully it's the right time of day, so that works for them, but the anxiety of getting dressed, of having to leave home, of having to meet a stranger in a strange environment, suddenly they get to my office and the person who brings them says, well, I don't know why they're acting like this, because they normally remember all this information. That's part of the frustration why some people have when they come to me and they say, I can't get a doctor to do a capacity assessment. And yes, that can be incredibly frustrating, but the reason typically is the doctors are in the same scenario. What if this individual could only get an appointment at a time of day that's not ideal for them? Or what if their medication hadn't yet kicked in? Or what if just the anxiety of being out of the house is enough to sort of spiral them into a stressful situation, which adversely affects our memory, even if we have no other conditions? And so that's a practical challenge. The reason why this is relevant and the reason I mention this is because the legal test for competency is just that. It's a legal test. And technically, only judges of our Supreme Courts are the ones who, in theory, can say whether somebody was competent or not. But lawyers are as close as we can get to being a judge in the sense of we read their decisions, we know the tests that they're looking at, and we can meet with clients and say, okay, if a judge were looking at you right now, this is why we think they would agree that you were competent or they think you weren't competent. And that's what I mentioned earlier, where sometimes we have to have multiple meetings, because maybe at the first meeting, things are going pretty well. At the second meeting, somebody's not presenting as competent at all, but at the third meeting, they're rallying, and maybe I need a fourth one just to make sure that the majority of times they were fine. So the reason I say this, just to conclude this slide, is that even if a doctor says capacity is something, sometimes depending on how frequently doctors deal with the individual of this state of health, will say now's the time to go in and see the lawyer, because the test for competency is not a medical test. So I can sometimes still do estate planning for clients who have started some decline, but still meet that legal threshold. So the rest of this presentation today is actually about the documents that we are putting into place. We tend to say that estate planning is not just doing your will, it's protecting you from your finances and your property, both in life and at death, but also looking after your physical person. And so today we're going to be talking about powers of attorney, personal directives, and briefly, as I mentioned, we'll touch on your wills. All of these are legal documents, and I should add right now that although we're moving to a technological age, the simple truth is that at this point in time, physical documents are still required. So British Columbia is making some advances to try and allow a bit of flexibility that way, but so far in the Atlantic, original documents are required. So it's very important that we put these thoughts to paper, that we sign them, and then those original documents are safeguarded and not lost. The presumption in law tends to be when documents are lost, that they were intentionally destroyed by the person who wrote them. So then you have to prove evidence that that wasn't in fact the case and that something had happened to them unintentionally. That results in legal expenses and so on. So just don't lose the documents in the first place. A power of attorney in and of itself is a document that allows me to, for example, give power to, I'm going to use Kirsty again from earlier in this presentation. Kirsty is now my attorney. I am the donor because I have given her powers, I've donated powers to her, and she steps into my legal shoes and she does what she needs to do to look after my affairs. A power of attorney is a little anomalous in the sense that it can be used while I'm still capable as well as when I'm not. So an example would be, we're supposed to get a snowstorm in Nova Scotia tomorrow, for whenever people are watching this later. And if I called Kirsty and said, you're my attorney, I am not stepping foot outside of my house tomorrow, but I desperately need something to be done at the bank. I'm going to send you with the power of attorney so you can go do that for me. Now, to be fair, banks don't make that quite as easy as we would like to, but I can send her and still be able to give her direction, and she comes back and she tells me what she did, and she's accountable to me, but she's acting as my agent. That's the presumption in a power of attorney as a starting point. It's a means of having somebody have authority to do things on my behalf. It is only for our financial affairs and our assets, our property. So property, of course, includes investments and bank accounts, but also land. Sometimes people hear property and they think it only means land, but legally it's all of those things. So it gives her the ability to do my banking, make decisions about my investments, sell my house, rent my house. It can allow her to have the authority to change my investments from, I don't know, I bank with one bank that she can't stand, so she moves my investments from this bank to that bank. Of course, if I'm capable, she's going to check with me before she goes and does all those things. But if I'm incapable, then we look to whether or not the document is what's called an enduring power of attorney. So in New Brunswick and in two of our provinces, it's called a Power of Attorney Act, and in two of the provinces, it's called an Enduring Power of Attorney Act. So I think we're the same as PEI, and I think New Brunswick and Newfoundland are the same. I could be wrong on that. I could have one of those flipped. But in any event, in the provinces where it's not necessarily an enduring power of attorney, within the body of the language itself, so Nova Scotia, the act itself is called the Power of Attorney Act, and it says this document must be written to say that it endures beyond the time that I've lost capacity. And if it has that magical language, then Kirsty can continue to do all of those things she was doing before, but under her own say-so, saying, okay, well, Jessica gave me this authority. I'm confident that this is the right thing to do on her behalf, and this is in her best interest, so I'm going to continue doing all of these things. And I've named her, so presumably I've given enough thought to make sure that I trust that she will make the right decisions, whether she can hear my voice in her subconscious or whether she's just looking at things objectively and saying, no, this is how I think this should be dealt with, and that's the right way to do things. The majority of powers of attorney that you hear about, and when lawyers talk about powers of attorney, more often than not, they are talking about a document that endures beyond a point where somebody loses competency and capacity. It endures for that duration. It endures, it only ends when that person dies, unless they were released at some point prior, and there's a bit of a formal process for that. So we assume if I name Kirsty and she's acting and I become incapable, that she will continue to act on my behalf until the moment that I die, at which point her authority ends at that moment. The key is, of course, I have to be competent when I make the instructions to give the power of attorney and when I sign the power of attorney, so that I understand fully who I'm naming, the scope of the power they have, their responsibility, and frankly, just the degree of power that allows the document affords them. On that note, what powers does an attorney have? I decide if I'm giving a power of attorney, if I'm donating those powers to Kirsty, it may be that I say, no, she can do absolutely anything that an attorney may do under the law. And that is incredibly broad. An attorney cannot, with the small exception New Brunswick that I'm not getting into, and I wouldn't take that as a general rule, but New Brunswick is really the only province in Canada that has this exception. Every other province, an attorney cannot write a will for the donor. So Kirsty can't write a will for me if she realizes I don't have one. That's an important point because some attorneys think they can and they cannot. Again, with the exception of this tiny little exception in New Brunswick. But what if I have a power of attorney that names my spouse? And my spouse and I are going on a trip, and I say, Kirsty, you're my closest friend. It just so happens that my house is selling while we're traveling. I don't want to give up this trip because I got this great ticket and we've been planning it for months and months. I wasn't expecting to sell the house, but I got this great offer. I'm going to give you a limited or specific power of attorney. And that may be just to sell my house. I could say that the powers I'm giving to her are purely to affect the sale of my house. Or I might say she has the ability to do anything, but it's only for a period of time. The 3 months that I'm traveling on this once in a lifetime trip with my spouse, she's got the ability to do anything in the 3 months, but when I'm back, that power is gone. So it's fairly, the flexibility is yours to give, and you can decide. This happens sometimes with some of my clients who are facing capacity issues, because they may say, oh, actually my child in other province is probably the best for an enduring power of attorney, but I have a couple of things that are happening, in the near future, sale of a house, something like that, and maybe I'll name a different child for the specific purpose of this, and then I'll put language in the document that they have to work together to the degree that that's necessary. So there's quite a bit of flexibility. A well-drafted power of attorney can take as long to think through and discuss as a solidly drafted will. So that's something to bear in mind. And then finally, on the note of power of attorney, who can be an attorney? Well, they have to be an adult. So in PI, that's 18. Everywhere else here, that's in the Atlantic, that's 19. They, most importantly, should be trustworthy. I do have clients who come to me and say, oh, I'm going to name little Johnny because he lives close by and somebody told me they have to be here, and my child, little Jimmy, out on the West Coast is actually really ideally suited to this role, but because he's so far away, I guess I'll go with little Johnny. But it's just interesting because every time little Johnny comes for Sunday dinner, all of the money in my wallet seems to be missing. And it's happened so often that I think maybe there's a connection. Little Johnny should not be somebody's attorney in that scenario. It may sound, eye roll worthy, but I've had those conversations with people. So it really is important. I'm more interested in having somebody that the donor trusts to act as an attorney and who they know will seek the assistance they need. The attorney doesn't have to be a mathematician. They don't have to be an accountant or a lawyer or an engineer or any other sort of professional. As long as they know when they're out of their league, so to speak, they need some help. I have a fairly strong understanding of certain tax issues when it comes to estate planning, but I would never take on filing somebody else's tax returns. I would always get the proper advice to do that. That type of conversation, sometimes I deal with attorneys who say, well, I didn't file the taxes for a couple of years because I didn't want to pay an accountant, and then I did it on my own, and now there seems to be a problem. Saving money sometimes is not the right answer if it's going to cause other problems for other people. Some people go with somebody neutral. So this slide says that maybe appoint a lawyer. I can't speak for every area. That is something that used to be done quite frequently. Again, I don't know if it was the confusion of attorney and lawyers, or it was simply for some lawyers in communities, they didn't want to say no when they took on that responsibility. But increasingly, lawyers will find it's a conflict of interest, or they'll be worried that they won't do justice to it if they're retired and don't want to sort of take on that role. Some people will come to me and say, I'd like to name my accountant or my financial advisor. Most times those individuals have to disclose the request to their superiors and their companies. And most companies will say, no, that's a conflict of interest, particularly for the investment advisors. They won't allow them to invest the money and be that person unless they're a relative. So there is also the possibility, if you deal with a bank that has a trust company, sometimes the trust companies are a nice neutral option. But it is important that you explore who you're naming in these documents with your lawyer when you're drafting them. And my biggest thing, twofold, one's on this bullet point, one's not, always have a couple of alternates, at least one. Time and time again, I meet with somebody who comes in and says, Mom had a power of attorney, but it named my dad named 10 years ago, then it named my older brother. My older brother died last year. I didn't realize I wasn't on here. Always better to have a list of people, because again, if suddenly I have a power of attorney and nobody's named, we have to go to court. We don't want to do that. So it's better to have a few people that you feel comfortable. If that person couldn't do it, then this person could, and this could. I don't think there's a harm in putting a few extra people in there. I worry when there's too few. But some people will say, can I name 2 people together? I'm leery to name 2 or more people together because it can cause practical issues if they have a disagreement. I've seen clients' bank accounts frozen while their 2 children are arguing about whether to pay things or not. So that's a problem. But also on a practical level, a lot of people deal with online banking these days, and the banks can't be certain when there's 2 people named as an attorney that both are on the other side of a computer terminal agreeing to pay a bill. So often, for example, if we're trying to ask somebody to take on this role, but in such a way that it doesn't overwhelm them or create too much of a burden, taking away that ability to do banking on weekends or evenings, that can be quite significant. And we can typically preserve that ability if we only name 1 person. But as soon as we name 2 or more, the banks will say, no, we can't be certain. They will typically lock down online access to what's called view only, that you can see the bank balances, but you can't redirect money or do any online banking. So next, we're going to talk about personal directives. So as I mentioned, personal directives are the name of the document in Nova Scotia. In Newfoundland, it's a advanced healthcare directive. It's sometimes also called a living will. In New Brunswick, it's a power of attorney for personal care. And in Prince Edward Island, it's a healthcare directive. In other provinces, they have different names again. Advanced healthcare directive is here not because we were focusing on Newfoundland and not our other neighboring provinces, but because it's one that's frequently used. When you Google things, that comes up a lot. I've seen Nova Scotia documents at the top say advanced healthcare directive made under the Personal Directives Act. In Nova Scotia, it's called a personal directive. It is possible in Nova Scotia, I'm not going to speak to the other provinces because I don't know this offhand, but in Nova Scotia, it is possible to name a personal directive as a component or within the power of attorney document. I'd never encourage that to be done for 2 practical reasons. One, if something happens to me, I don't want my bank having to know what my healthcare decisions are, and I don't need my hospital to know what I'm telling my bank or how to deal with my real estate. So those should be separate for very practical reasons. The second reason is because, again, some people will insist on naming 2 people as attorneys, co-attorneys under the power of attorney. And in Nova Scotia, the personal directives legislation is very clear that we can only name 1 person at a time. So if the personal directive component within your power of attorney says, I name my attorneys as my delegates, and your power of attorney names 2 people, effectively, you don't have a personal directive. So for those of you in Nova Scotia, check your documents just to see. Personal Directives Act came into being in Nova Scotia in 2010. Prior to that, we had no legislation that recognized our instructions legally for how to look after our health and our personal care and our end of life decisions, absent, frankly, just sort of a letter of wishes. And that's partially tied into the living will idea. Living wills are obviously much broader than just in Nova Scotia, but living wills are really conceptually just dealing with end of life decisions, and they aren't legal documents per se. They may be a component within a personal directive or an advanced healthcare directive or a healthcare directive and so on. But in sum, personal directives allow me to say to whoever I've named as my delegate, this is how I want to be looked after if I can no longer advocate for myself. In Nova Scotia, our legislation is very clear that this document is only engaged when I am unable to advocate for myself. So if I'm unconscious, that's pretty clear. But if I'm lucid but unable to verbalize, so I have a tube down my throat, but I can still blink my eyes or squeeze hands. I am, because of drugs, I'm unable to keep my eyes open. I can't speak, but I can still squeeze hands. If there is a means for me to communicate and it's clear that I'm understanding the questions and the context and I'm making right sense of things, then my medical care team, my personal care team, my delegate should all be looking to me to answer questions as long as it's clear I'm able. If I get to a point where I've passed that point and I'm no longer lucid, I can't tell daylight from nighttime, I can't tell whether the sky is fluorescent yellow or purple dot or polka dot purple, if I'm clearly not making sense, at that point, my delegate steps in and advocates for me. It's incredibly important that people in this role understand that part of their job to advocate for me is to make sure that if it is all possible for me to be involved in an appointment at the time that's optimal for me to be involved, that is organized. So the example best here would be sundowning. If everybody knows I start sundowning around 3:30, 4 o'clock in the afternoon because I have Alzheimer's, then try to make morning appointments for me. If I'm not an early morning appointment person, do your best to try and make appointments for me around midday. The reality is that's something that people forget. Sometimes medical teams forget, some are excellent, but sometimes they forget, and it's easier and faster to look to the person who's able and quicker to comprehend and answer and so on. But the reality is that as long as I am able to follow conversations, no matter how slow it is for me to sort of affirm what I want done, I should still be calling the shots. And my delegate's job, as much as anything, is to make sure that if I can speak for myself, that I continue to be able to do so and that people listen to me, but that when I can't, that then they step in and they advocate on my behalf. So I jumped ahead a little bit, but essentially the personal directive, this slide applies whichever province you're in, whatever the name of your document is, that slide applies in terms of it's setting out our personal care decisions, which include healthcare. And on that note, in Nova Scotia, personal care is specifically defined to include the items on this bulleted list. So nutrition, hygiene, healthcare, social activities, comfort, recreation, residence, clothing. If I don't have a personal directive in Nova Scotia, then back to what I mentioned earlier, if I don't have a named delegate, so if I have a personal directive and it names Kirsty and she can't act, then I'm in trouble because I need a backup. So again, the comment I made earlier about an attorney, have a backup for your personal directive as well. But in the absence of a personal directive that works, then two things happen. One, that list of statutory decision makers, which are, you know, again, there's some of the substitute decision makers, but in Nova Scotia, because they're set out by statute, it's the statutory decision maker. They'll go through that list and figure out who it may be. So if I have a spouse, and for whatever reason my spouse wasn't named before, but he's still able or she's still able and can act at that point, then fine, they can step in and be there. If I only have one child, I have no spouse, and children are named next, then it's my child. If I'm estranged and I haven't been in touch with them for over a year, don't worry, the provisions say that somebody's not going to be able to step in and make decisions about you if you're estranged from them. But that's all the more reason why you should make sure you have your intentions down on paper. But here's the thing. For whatever reason, I didn't name my child. My child and I were in contact. My child now is able to come and act as that statutory decision maker. The problem is the scope of what they're able to do by virtue of the statute is limited to making medical care decisions for me. So if I'm unconscious, saying yes or no to treatment and surgery, etc. They are able to take steps to arrange for support services, typically in my home. And they can also advocate for me to get placed into long-term or continuing care. But that's the scope and limit of their abilities absent an actual personal directive. The legislation says, hey, if Jessica didn't go and write a personal directive, then fine, we'll come up with this statutory list of who can make decisions for her, but we're only giving them this scope of responsibility because we don't know that Jessica wants this person to also then be able to dictate nutrition, hygiene, clothing, and all those other things, which seems a little crazy in some respects, but makes a lot of sense in others because they're deeming who should be that person. And if I haven't done it, then maybe they've actually got the wrong person. So they're a little cautious. So on that note, you want to make sure that you have a document that it names a couple of people and a few in order. If you want them to speak with one another, you can put language in there to say they should consult even if only one person is acting. But you also want to typically have a fairly broad document that allows them to look after you. And bear in mind this last point before we go on to the next slide. My delegate under my personal directive has no financial control over my assets. So whoever my delegate is has to work with my attorney. Some people name the same person for this reason, but other people have the luxury of more than one individual who can help them. So they name, son Jack on the power of attorney and daughter Jill on the personal directive, or vice versa. Either way, Jack and Jill then need to work together because, can't remember who I said, but let's say Jill was doing personal care. If Jill wants me to live in the penthouse of a continuing care establishment, thanks, Jill, and Jack says, that's a very nice idea, Jill, but mom will be out of money in 3 years tops if we do that, then they need to come to an arrangement whereby Jill is still satisfied I'm getting the right care, but Jack's doing his best to make sure that my assets are going to last and look after me as long as possible. So the final note on this one, and then we're going to talk briefly about the will. What if I have no power of attorney and no personal directive? And what if, as I said, that statutory decision maker either doesn't exist or the scope is too limited and there needs to be more coverage? Then we're looking in Nova Scotia at applying to the court under the legislation I mentioned earlier, the Adult Capacity and Decision Making Act. The person who is named is now called a representative. They are going to court to seek representation over me. The catch with these is they are expensive. The legislation is intended to try and make things a little smoother, but the reality is there's still a lot of paperwork to do, so the legal expenses can be fairly onerous. And also on top of that, there's a bonding requirement, meaning that somebody needs to be able to say to the court, Kirsty isn't going to abscond with Jessica's money, but just in case she did, she's got a bond into the court for 1.25 times the value of Jessica's estate, so that the money will still end up going to look after me or ultimately my loved ones. Many people don't have a family member with enough money to say, oh, I'll vouch for Kirsty. I'll put in, if my estate's $100,000, I'll put in $125,000 to the court because I'm positive that Kirsty's fine. A lot of people don't have that luxury or that type of cash. Again, 1.25 times whatever the value is. So if my estate's higher, the bond is higher. In that scenario, they have to go to insurance companies, and those can cost several $1,000s a year depending on the size of the bond. So that's something to bear in mind. There also needs to be various paperwork, including a capacity assessment. So if somebody's just starting to decline and then they're presented with, we need to get a capacity assessment for you, that can be touchy and a little challenging by times. But in Nova Scotia, one of the things that people find the most upsetting is that one of the requirements is also that we need a police check. I have spouses of 50, 60 years where they just never knew they had to get a power of attorney. And then I say to one, I'm sorry, I need you to get a police check so we can say to the court, you can look after your spouse. They find that incredibly insulting. Children as well, who have looked after and doted on their parents for years. Objectively, we know why they need police checks, because there are people who take advantage of their parents or loved ones with these documents. But for those who are truly well-intended and would never even think if they knew that, I should say, they will get incredibly upset and sometimes angry that this is even a requirement. So again, if you have done nothing else yet for your own estate planning, or if there's still an opportunity for your loved one, please go and pursue getting a power of attorney and a personal directive. So just to wrap things up a little bit, we always spend a couple of minutes talking about the will. So again, this is our final document in our basic estate plan. So we've talked about our financial affairs while we're living. We've talked about our health care and personal care while we're living. The moment we die, both of those previous documents we've discussed die with us. And at that point, the will steps in. Our executor has a job very similar to the attorney insofar as their job is to collect all of our assets. And I'm jumping ahead of the slide. Let me go to the next slide. My executor collects all of my assets. They determine what my debts are. Sometimes my debt is really just income tax. Other times I have other debts as well. But either way, they collect all of those assets. They pay any debts that I owe. And then ultimately, they look to my will to determine how to distribute whatever's left over that's available to be distributed. We've touched on that our executor, also a trustee, is the person who we name to look after things. And similar to the conversation we had about who to name as your attorney under the power of attorney, we talk about who to choose as your executor in a very similar fashion. Some people name the same individual if they've been looking after one person's affairs under their power of attorney for a number of years. For some, that's very logical to then say, well, I've already been filing the taxes. I know where all the bank accounts are. I know where all the assets are. I know this, that, or the other. It makes sense that I just continue to act as executor. That is logical. Other people have, as I mentioned, multiple people to choose from. And if that's the case, then they can say, you know what, Jack, I'm naming you as attorney, Jill as delegate, and Joey, you're going to be named as my executor. And so, you know, in that scenario, Jack and Joey have a little bit of a transition meeting, and then Joey takes off and finishes off on the estate side. So it all depends. But again, we want somebody who's trustworthy, who will know when they need help, who will know how to manage the family dynamics involved. One of the questions that gets posed to me a lot, well, two actually, and they're related. One is that the person has to be in the province and that they have to be younger. Let me address it at the province issue first, because it actually ties into all of those documents. If my sister in BC is still the best possible person for me to name because I trust her implicitly and she knows my kids and she knows what I would want done, then even though she's in BC and even though she's my older sister, I may still name her. What I need to appreciate is that a lot of the expenses of her, for example, when she has to travel here and so on, those are all expenses that my estate is expected to reimburse her. When somebody takes on those roles, they're not supposed to go out of pocket for that. Our assets repay them. So it's more expensive when I name somebody out of province, but if I'm absolutely certain that that's the way that my estate is going to avoid having all this fight and expense because my kids can't get along, then that's still a little extra money. That's probably a lot less than what happens if people start fighting in particular about my estate. So geography is not ultimately a reason not to name somebody. I've had a number of files where the wrong person was named because somebody said it had to be younger and in province. Not necessarily the case. Again, I would remind you about that list of people. If my sister is still my first choice, then maybe I name my sister, and then maybe I name her even ahead of my spouse, and then I name, you know, child A, B, or C, or best friend, or what have you. Again, bear that in mind. And in terms of living in the province, on the will side, the important thing is that in Nova Scotia, we have to, and the other provinces I think have something similar, but at the other Atlantic provinces. In Nova Scotia, if I name an executor in my will who doesn't live in Nova Scotia, our law defaults to say, hey, if they're not subject to the court of Nova Scotia because they live here, then they have to also be bonded in order to act as an executor. And that can be problematic because, again, it's expense and it's 1.5 times the size of the estate. So if you are doing a will that names somebody out of province, if you explicitly waive the requirement that they pay security, then you've taken care of that and they don't need to worry about it. They can live wherever, and you've specifically said that's fine. If the last question I sometimes get is, can somebody name their spouse or a child as their executor if they're also benefiting? And yes, you can. There's issues about how you sign a will to make sure that we don't have a problem, but the reality is that indeed you can name your spouse as your executor and then of course leave everything to your spouse. But if your spouse isn't living, then have somebody as a backup and have everything else go to your kids. But that brings me to my last point. Again, it's very important that you have at least one backup, and it doesn't hurt to have a couple. So in conclusion, we have, somehow my slide just went right ahead. So we've left in this slide deck for you a little summary of what I was mentioning about while you're alive, which documents apply. So again, financial decisions are your power of attorney, but if you have no power of attorney, then we have to go to court to seek representation. If I only want somebody to be able to deal with my health care, admission to continuing care, and again, those support services at home, my personal directive can do that. Otherwise, it's that statutory decision maker with that default in the legislation. And if I don't have either of those in place, then we have to go to court for representation. And if we want somebody to be able to look after all of those other care decisions that I mentioned, and we don't have a personal directive, again, we have to go to court to seek representation. So if nothing else, please go get a power of attorney and ideally a personal directive as well. And on that last note, now the slide won't move. Okay, here we go. we often give some resources. The Personal Directives Act, when they came out in 2010, did this lovely resource, which is the first link in these materials, and it's got some information. But I would encourage you to visit the Legal Information Society of Nova Scotia. Again, for those of you in the other Atlantic provinces, take that with a grain of salt, but it's still a good exercise. You can go there, and they've got a personal directive app where you can go in and it will ask you questions and you'll put everything together and it will generate a document. It doesn't save any of the information. I think it holds onto it for 48 hours in a cache of sorts, so you can print it or work on it, and then it disappears forever. But if you print it, then at least you've got a personal directive, and it's a good exercise to go through. So thank you for your time.
Thank you, Jessica, for your time, and lots and lots of very important things to think about and food for thought. So thank you to Jessica, and thank you to you for joining us for session 2 in the 6-part Family Caregiver Education series brought to you by the Alzheimer's Society of Nova Scotia. It's never too early or too late to connect with us. So please give us a call or send us an email if you have questions or need to talk. And the number for the Nova Scotia Society is here on your screen, 1-800-611-6345. And if you're not in Nova Scotia, please contact your local Alzheimer's Society in the province where you live. Thank you very much.